Um, so to begin, first thing to sort of say is the invite for this webinar went out to VWV's employment e-zine mailing list, and yet here we are, a couple of immigration lawyers having hijacked the session. We normally like to hijack an employment team webinar around this time of year because it's around this time of year that we usually get some fairly chunky immigration updates from the Home Office, and this year is no exception. So, in terms of what we're going to cover this morning, I'll start just by dealing with a few stats, just to sort of give you the sort of picture of where what's happening to the sort of as far as the immigration landscape is concerned. Um, and one of the things we want to focus on within that is sort of trends that we're noticing as far as the Home Office's compliance activities are concerned. And leading on from that, then Nishil will take over and take you through a relatively recent case which deals with the revocation of a sponsor license, and we think has some pretty useful lessons to be learned, just in terms of the things that particular sponsor got wrong, and how the courts dealt with that. Um, Nishil's then going to take you through some recent updates to the sponsor guidance, some sort of general duties, and then I'll step back in and look at some specific duties that have been imposed recently in updates to the sponsor guidance, some immigration rule changes, and then I'm going to finish up with an update on right to work checks. As I say, quite a bit to cover. Let's crack on. In terms of what's happening as far as immigration is concerned in the UK, the trends over recent years have been has been one of long-term net migration falling. We had a large peak in the summer of 2023, and since then, changes made to the immigration system, to the immigration rules, have had a massive effect on that, to the extent that there are some predictions I've read that at some point this year we may get reports of negative net migration, so more people leaving the UK than entering on a long-term basis, which is obviously something which hasn't happened for many years, decades, in fact. Um, One of the largest drivers of this change have been the changes which have been made to the skilled worker category and its sort of subcategory, if you like, the health and care worker visa. Bulk of those changes are brought in sort of 2024, 2025, and as a result of that, as you can see from the sort of the second of those two graphs on this slide, yeah, large decline in number of skilled worker visa applications and grants. And just as a reminder, the sort of the significant changes that were brought in last summer were the increase in the skill level requirement, so that it's a significant number of jobs no longer qualify for sponsorship under the skilled worker route. There are some exceptions relating to what's still referred to as the immigration salary list. There's a temporary shortage list, and there are some transitional measures, but for the most part, jobs that are sort of assessed as being below degree level in their skill requirements no longer qualify. There have been over the last few years significant increases in the minimum salary requirements, and as far as recruitment of health and care workers are concerned, for care workers, senior care workers, it's no longer possible for those people to apply for entry clearance if you're coming under that category. So huge changes as far as that's concerned. Another big change, which is sort of a hangover, if you like, from the boom years, where lots of applications were being made, um, are that we still have nearly 125,000 sponsors in the UK. So employers, organisations that have applied for licenses to sponsor workers. There's as at the end of last year, there were 123,911 work visa sponsors, and I've just included on that slide just some comparators. In 2014, about 27,000, 2020, 30,000. And if you look at a chart for the number of sponsors, it remained pretty static around 30,000 for quite some time, and then we had this sort of huge increase from Brexit onwards, effectively to the point where we are today. The rate of growth has slowed, but it is still the number of sponsors is increasing. Also on the increase is the amount of compliance activity. This is a chart which shows the number of letters of suspension and letters of revocation sent out by the Home Office to sponsors in the skilled worker route each quarter since the beginning of 2019. And I don't really have to describe the graph, spend an awful lot of time describing the graph. You can see that up until sort of middle of 2023, there was sort of a fairly consistent amount of activity. Particularly if you take out the pandemic years, less than 200 letters of revocation and suspension being sent out every quarter, and then suddenly that activity increases to the extent where in the final quarter of 2025 we had a record-breaking year, 1,600 suspension letters sent out and over 1,500 revocations of licenses upheld. I should point out, I mean, there is some double counting in these figures. So a lot of the time, a suspension letter will then be followed by a revocation letter. But actually, one of the things we've seen in recent months is actually UKVI going straight from suspicions and concerns to revocation rather than issuing a suspension letter in the first instance. Nishil's going to talk in a little bit more detail, as I said earlier, about in a few moments about that specific case with some specific things for you to think about in terms of your own sponsorship activities. But just in terms of some sort of trends that we're spotting anecdotally, the sorts of things that we understand are going on as far as this increase in compliance activity. One of the big drivers has been increased data sharing between HMRC and UKVI. So UKVI are able to get payroll data directly from HMRC and use that to sort of extrapolate and get inferences. And what they're looking for in particular are situations, suspicions of sponsors who are underpaying their sponsored workers. As we understand it, the data that they get initially in its rawest form doesn't confirm definitively one way or another whether someone is being underpaid or not, but it gives them an indication, at which point they will write out to sponsors, and they won't just write out in relation to the workers who they have concerns about from the data that they've got from HMRC. They will ask for all of your payroll data as it relates to sponsored workers, and essentially at that point they're on a fishing exercise. And if they find any breaches, as I said a few moments ago, quite often what that results in is a letter saying we are revoking your license. We found that you're underpaying your sponsored workers. That's a fundamental breach. There's no, and then at that point, the only response, the only way you can address that is by an application to the High Court for a judicial review of that decision. There's no further dialogue with the Home Office as there would be with a suspension letter. A few other things just to flag before Nishil gets into that detail from that specific case. Think about Record keeping duties. One of the things that quite often gets flagged is failure to identify the date on which a sponsored worker entered the UK following the approval of their overseas visa application. What they're looking for is checking that they've entered in accordance with that entry clearance, and not entered in some other capacity, such as a visitor first. Think about your right to work checking processes. I will talk about that in far more detail a bit later on. And then making sure that you've got the appropriate evidence of the recruitment activity that led to you making a decision in relation to somebody's sponsorship. And one of the things they're looking for is your choice of occupation code for the person who's being sponsored. If it's an occupation code which is sort of maybe out of the ordinary, or one that you don't normally deal with, and you've had to put a bit of thought into why you've selected that occupation code, maybe think about how you're able to justify that, and keep a file note so that you can justify your actions at a later stage. Finally, before I hand over, think about your reporting activities as well. One of the ways One of the things that sometimes comes out from these phishing exercises that the Home Office are carrying out is where somebody has been sponsored and they're then on a period of reduced pay for legitimate reasons, so on maternity leave, long-term sickness. That would be a reportable reduction in salary, albeit one that is permitted. But if you haven't reported it, then UKVI won't know that that's a justifiable or a permitted reduction in salary, and that's when they'll start their phishing expedition. So make sure you're keeping on top of those sorts of things. And then finally, just to mention here, that's a perennial problem. Forgetting to report that somebody is no longer sponsored by you is also one that's quite often missed. So somebody who's been granted indefinite leave to remain, for example, is no longer sponsored, and therefore that needs to be reported. Similarly, if they've moved to another sponsor, that would also be reportable. Okay, Nishil, over to you.
Thanks, Thanks, Tom. So, as Tom was saying, this High Court decision is a really important case to really show how practical standards are expected of sponsors, and it's a good example of where a sponsor has sort of breached their sponsor license obligations, and the Home Office have decided to revoke their license, and even it has been upheld by the court as well. So this case involves a business called Southcroft Healthcare Lodge, and it's a care provider which has 16 care homes and over 100 employees. Now, this organization had a sponsor license, and they were audited by the Home Office on the 4th of May 2023 and the 25th of May 2023. And as a result of their compliance audit, unfortunately, their license was revoked. Next slide, please. Now, this organization had a number of breaches which were addressed by the Home Office. And I've listed them here exactly what those breaches are. But what I want to highlight is some particular sort of three breaches, which are the main reasons as to why the Home Office revoked the license. Now, as you can see, as I said, there are a number of breaches, and actually any of these breaches can cause the revocation of your license. But these three key areas were the main reasons why it was revoked. So the first area was in terms of the assignment of the certificate of sponsorships. Now, the Home Office found that with this organization, 97 certificate sponsorships were assigned under the SOC code 6145. In fact, this SOC code was completely incorrect from what the individuals were doing within the organization. And the organization was also not accredited by the CQC. So as a result of the audit, the Home Office found that these employees were doing a completely different job role than what was actually on their certificate sponsorship. And that was a major breach within the organization. Another area that they found was in terms of the salary. So they found 4 individuals were not being paid the correct salary as per their certificate sponsorships. Now, if you see sometimes with care providers, they do have variable pay across various months, and it all really depends on the contracts that these organizations win and the work that's involved. Now, the Home Office had looked at the salaries of these particular individuals, and they found that over a particular threshold, over a particular period, these individuals were not being paid the annual salary as stated on their certificate of sponsorship. So, as a result, this is a major breach of their sponsor license obligations. Now, a third breach I would like to highlight is in terms of the documents that the Home Office have asked the organisation to provide. Once they provide a letter to ask for further information from the sponsor. Now, with this organisation, they were asked to provide information for two sponsored workers um, that were sponsored within the organisation, and that this sponsor did not provide this evidence that they needed before they revoked the license. And as a result, because the sponsor did not they did not address the queries that they had in place, and they did not do that in time, the Home Office went straight to revocation as opposed to asking them for further time to provide those documents. So other breaches that were also acknowledged were there was issues with their right to work checks. There were security breaches in terms of they found that there was password sharing between different users within the level one users. And also when the Home Office came for the compliance visit, they found that a lot of the users were not aware of their sponsor license obligations when they spoke to these individuals. And they also found that there was inadequate systems to monitor and track visa expiry dates and authorized absences. So as a result of these breaches, the Home Office did decide to revoke the sponsor license. And the sponsor decided to take the case to the High Court, and they decided to argue with a number of these claims. Next slide, please. So in terms of the allocating the wrong incorrect SOC codes to these individuals, the claimant had stated to the immigration judge that it wasn't actually just because of dishonesty and bad faith that they had assigned the certificate sponsorship. It was a genuine, these were genuine roles that were involved within the organization. And it wasn't just a flaw on their half. They actually, they wanted the Home Office to be able to make a rational and reasoned understanding of the situation that the sponsor was going through. Now, the judge actually upheld the Home Office's statement, and they said that the sponsor is responsible for assigning the correct SOC code, and the timing that the UKVI found the incorrect SOC code is not relevant, as sponsorship operates on trust and responsibility. So it's always on the onus of the sponsor to ensure that the SOC code that the individual is being sponsored under is the correct SOC code. And it doesn't matter about the timing of when the Home Office found out about this breach. They should have done the correct SOC code right from the beginning. In terms of the documents that were required for those two sponsored workers, the claimant and the sponsor argued that the Home Office misconstrued the guidance and erred in law in holding that the claimant had not provided the requested documents. Now, the courts upheld the Home Office decision again and said that if the Home Office asks for any particular documents and they do not provide these documents, then this can justify revocation. And in this case, documents were not provided, and the explanations for why these documents were not provided were insufficient. And as a result of even just this single breach of this requirement, this can justify revocation. So even without all these breaches that this sponsor had, even if they didn't provide these documents in the correct time and they didn't provide it in the specified order, then they can actually look at revocating the license. Now, the final thing I want to discuss in terms of the leniency is the sponsor argued that we have to look at the business on a whole. It's not, they haven't done these breaches as a result of being ingenuine. They're a genuine business. You have to look at the overall picture. Having a revocation of the license, it can affect the whole business on a whole. It can affect the ability to employ these individuals. It can impact the patients that these individuals are dealing with. It can impact the business on a whole. Now, the immigration judge upheld again the Home Office decision and said that downgrading the license as an alternative is not a discretion, and sorry, downgrading the license as an alternative revocation was within the discretion, but was not deemed appropriate. And the UKVI is not required to assess the impact of revocation on the claimant's business, employees, service users, or the wider social care sector. So you may see you as a business with, a very good history, but there may be some breaches within your organization. Now, even though you've got this good character and you've got this good history, now you've got these breaches, the Home Office can look to revoke your license. So they're not no longer going to be lenient on what you had before. Next slide, please. So some of the key takeaways, really where I want to address in these areas, is that where you are assigning certificate sponsorships, please make sure that the SOC code, the job descriptions are accurate to the roles that you're sponsoring these individuals for. Make sure that the pay that you're employing these employees is correct and in line with what you put on the certificate sponsorship. Now, the Home Office are changing the way that they're assessing the salary requirements, which Tom will discuss a bit later. And they'll no longer look at the salaries from an annual basis. They will look at it from a across a period basis, depending on whether you've on a variable contract, whether you're on a permanent contract. And as I said, Tom will speak about that later. Make sure that you're reporting changes to the on the sponsor management system. So if there are changes to the individual's job roles, job descriptions, anything like that, organization details, make sure that those are changed within the system. Ensure that you do have the robust places to monitor visa expiry dates and ensure compliance. The main thing is making sure that you respond to Home Office requests quickly and in time and in accordance with the deadline. Now, we find, for example, at Christmas time, I had an individual who had applied for an undefined certificate sponsorship, and they were lucky to get their priority service request. And it was during the Christmas period. So it was, I think, the priority request came through on the 24th of December. And what happened was that the Home Office had sent a follow-up email on around the 27th of December asking for some further information from the sponsor. And during that time, the sponsor actually wasn't working because they had went on holiday and there was no one to cover their mailbox. And by the time the sponsor had looked at their mailbox in January, the deadline had passed. And the sponsor had asked for an extension of the time. And instead of the Home Office even responding to that email, they just completely rejected the undefined certificate sponsorship request and asked the sponsor to reply again. So it just shows that they're not being lenient on these deadlines. If you do have a deadline, make sure that you adhere to it and you're providing the documents that they're asking for in the specified format. We're also finding that if you're, for example, asked to provide bank statements, please make sure that the bank statements do show the bank logo, they do show account number, they do show the sort code, the organization's name, because any of these if you're providing bank statements with any of this missing, then the Home Office will just look to reject your request. And then the final thing I want to talk about is just making sure that you're proactively reviewing the sponsor license. Level one users logging into your sponsor management system, just checking your organization details, checking the users on your sponsor license, updating anybody who's being sponsored under you, making sure that that's a consistent process that you have within your organization. Now, where we're finding where the Home Office are asking for information is where you're asking for undefined certificate sponsorship requests or defined certificate sponsorship requests. So where you are making these requests, a majority of the time, the Home Office will come back to you and ask you for more information as to the role that you're looking to assign for, but not just only the role for this individual, but also about the payroll data for your whole organization, about your organizational chart for all the individuals that you're employing, and also sometimes your right to work checks. So if you are looking to make any requests, what I would suggest is just make sure that you look at your sponsor management system first of all. Make sure that everything is updated correctly. Make sure that you have everything in place, because once that request is submitted, then the Home Office do have the obligation to request further information. So that's a good time to really audit what you have in place. The next slide, please. So in March of this year, the Home Office updated their sponsor license guidance to make it to make it stronger and tighten the enforcement action on sponsors. And there was some particular wording within the sponsor guidance which changed. And it basically said that sponsorship is no longer a we're not working to we're not you're not working with the Home Office to ensure that there's compliance. In fact, if you've got a sponsor license, it is voluntary for an organization to have a sponsor license, and it's almost a membership. And if there is a flaw in you breaching any of these sponsor license obligations or any of the guidance they have in place, then they can revoke that membership. So the onus is on the sponsor. It's a voluntary process. It's a voluntary license that you have in place, and it's the onus on the sponsor to ensure that they've read the sponsor license guidance and they are acting in accordance with that. So where I would like to focus is on a few areas of the guidance. So there is a lower threshold for compliance action. So the Home Office can take compliance action against any sponsor. So regardless of your history, regardless of how big your organization is. So if they reasonably suspect that breach of sponsor guidance has occurred or is likely to occur, then they can look to revoke your license. So this falls onto, the license, as I said, it's not just, they're not going to revoke license for people who are operating malpractice on a persistent basis. It could happen to anybody. So it's just really important to ensure that you're auditing all the processes that you have in place. One of the biggest changes within the guidance is an obligation for the sponsor to ensure that they've read and know the guidance. So it is now a requirement for all license holders and prospective sponsors to read all relevant parts of the sponsor guidance, including the three main parts, appendices, glossary, and the guidance specific to any route you are licensed or applying to be licensed on. So if you do have a global mobility part of your license, then it's important to read that guidance. If you've got the skilled worker guidance, you have to read that part of the guidance. So whichever guidance you're being sponsored under, make sure that you read every part of it. Because as I said, the Home Office are not going to be lenient in terms of you not being able to adhere to the rules that they have in place. Next slide, please. Now, one of the changes within the guidance was, in fact, in terms of the terminology of genuine vacancy. Now, they changed the terminology from genuine vacancy to eligible role. So that is a big change. And they've changed the assessment based on that. So where you're a sponsor, you now have to show that you've got an eligible role in place. And there is a kind of a three-part requirement. So the first part is to show that the eligible role has to exist or be reasonably expected to exist. The second part is that your worker must be able to carry out the duties and responsibilities that are required for the sponsorship that they are going to be undergoing. The third part is ensuring that you're paying the sponsor, you're paying the worker the correct salary as ascertained within the certificate sponsorship that you've assigned for that individual. And then finally, the role must be suitable for the sponsoring organization, considering the business model and the operational plans. Now, I spoke to the Home Office a few weeks ago, and they were saying that they had a number of organizations, because the Standard Occupational Code has reduced significantly. There are a number of organizations that they were trying to feed into roles within their organization that didn't really exist. And one example they were saying with chefs, because chefs is no longer applicable within the sponsorship. And they were saying that there were a number of restaurants and sort of takeaway businesses that were now looking to sponsor food technicians. And so they were saying that, it's not just something that you can just conjure up a particular role. They will look at your business on the whole, and they will look at the type of roles that you're hiring for. And so if you have a random role that you've just decided to sponsor somebody for, then they will look at that. So make sure that if you are looking to sponsor somebody, make sure that it is within the remit of what your organization does. So now I'd like to just hand it over to Tom, who will speak about some of the right to work updates.
couldn't find the unmute. Thanks, Nishil. Yes, so thank you. Those are some sort of, I suppose, what you might call sort of general or overarching updates to the sponsor guidance, which I think to a large extent are designed to put the fear of God into us all, but also are there to sort of really strengthen the Home Office's hand when they are starting their enforcement activity against sponsors. And they're designed not just to catch out those, as Nishal was saying, who are um, deliberately looking to exploit workers or undermine the immigration system. That they will, by design, catch out people who just haven't read the guidance carefully enough, or don't quite understand the seriousness with which the Home Office expect sponsors to be operating. I'm going to take you through some specific updates now. One is a record keeping duty, and it's now a requirement to retain records to demonstrate that you've provided information to your sponsored workers about their employment rights in the UK. So, as we can see from the slide, that's specifically set out within Appendix D, and then in Part One of the sponsor guidance, it gives us a bit more flavour, a bit more detail about the sorts of rights that they're talking about. So as you can see from that list, it's not just things that will be contained within the sponsored workers employment contract or their Section 1 statement. It goes beyond that. So it's things like being made aware of duties under the Equality Act, trade union membership, how to raise grievances. So a lot of these things will be contained, particularly if you're a larger organisation, within an employment manual. But you need to think about how you're sort of drawing these things to your sponsored workers' attention, and then how you're going to be able to evidence that. And that could be, just by showing them your induction manual and your induction training schedule. But if you're a smaller organisation, it might not be quite so formalised, and so you might just need to think about how you do that. The next change is the one that Nishal's mentioned already, which is the change to the rules on calculating salaries. What seems to have happened from a lot of the enforcement activity, particularly in organisations where sponsored workers are in receipt of variable pay, that where UKVI have said, well, for that month, that individual wasn't receiving the required salary, the organisation said, yes, but by the end of the year, they will have received the salary which we specified on their certificate of sponsorship because we anticipate them working more at a particular point in the year. And so what they've done is change the rules. And so the sort of starting point is that if the sponsored worker is paid monthly, then they will expect to see that every month they are receiving at least 1/12 of the salary that's on their certificate of sponsorship. In situations where they're paid differently, have a different pay pattern, so maybe paid every 3 months, which apparently goes on, but I don't see it very often. Then they would expect them to receive a quarter of their pay every 3 months, but only where that's provided for in the employment contract. If your contract says we'll pay you monthly, but you're only paying them every 3 months, obviously that's a breach of contract and won't be looked on kindly by either the employment tribunal or indeed the immigration authorities. And for those with irregular working patterns, they will look at the individual's salary, their pay over a 17-week period, and they will look at that on a rolling basis. So they'll look at any 17-week period, and if that ever drops below 1750, I never know how this works, 1750 seconds, 1752ths of the COS salary over that period, then that will be deemed to be a breach. And as I mentioned right near the beginning, we've got this increased level of data sharing between the Home Office and HMRC, which they will use to enforce and manage enforcement in their area. So do watch out for that, particularly if you have staff on variable pay or working irregular working patterns. I'm going to come back to some changes in the sponsor guidance in a moment, but before I do that, I just want to flag a couple of changes to the immigration rules which are relevant to some of you. So the first is that uh, uh, we have a new concept in immigration law. The Home Office is always coming up with weird and wonderful um, ways of changing the rules and throwing new concepts at us. And this new concept is that of the visa break. And UKVI were getting concerned about the number of legal migrants coming to the UK as students or as workers from Afghanistan, Cameroon, Myanmar, and Sudan, and then going on to apply for asylum. And as a result of that, if you're from one of those four countries, you are no longer able to apply for a student visa. And if you're from Afghanistan, you're no longer able to apply for a skilled worker visa. And that's sort of an absolute prohibition for those nationalities. The policy will be reviewed in 18 months' time, although there's no sunset clause on that break. So until they change the rules, that will remain in force. But as I say, it will be reviewed in just under 18 months' time. Um, Another important change, although this has been in force for a few months now, has been an increase in the English language threshold for the skilled worker route. So it's now a requirement to demonstrate that you have English language to level B2 on the Common European Framework of Reference for Languages. That's increased from B1. It doesn't sound like a very big jump, but actually we've seen a few instances already where people who we've spoken with and have perfectly good spoken English at the very least have would have passed at B1, but haven't made the grade at B2. And so maybe just something if you're recruiting people from countries where there is which aren't deemed to be native English speaking, then they will need to get through an English language requirement, and it might be that they maybe need a little bit more time to get through that in some cases. Also of relevance that as of March next year, when anybody applying for indefinite leave to remain will need to demonstrate that they have English to that level two, level B2, again, which is an increase from level B1. A lot of the time, say under the skilled worker route, you might have already demonstrated your English language, but sometimes people who've done that in the past will have only had to do it to B1, and so would maybe need to take another test before they apply for indefinite leave to remain. So maybe just one to watch out for in some cases there. Right, back to an update on the sponsor guidance, and this is a fairly bit of a concerning one. This was a change that was introduced earlier this month. And as you can see from the slide, what they're saying now is that you are required to check that any worker who you sponsor has permission to enter or stay in the UK and can do the work in question. So you need to do a right to work check on the people you sponsor. And in addition to that, on anyone who you wish to employ or directly engage. Not only are they extending the requirement to do right to work, or of course, you should be doing right to work checks on everybody you employ anybody anyway. But in the past, it wasn't an explicit sponsorship duty, and so it was just something that they tended to look for rather than enforcing as a mandatory requirement. But now what they're saying is you need to be doing right to work checks on all of your employees and make sure you've got a statutory excuse for all of them. And in addition to that, it's this wording, or those who you directly engage. So suggesting it spans beyond that. Well, more than suggesting, telling us that it goes beyond people who you employ, and is extended to people who you might engage on a workers' contract, so people on 0 hours contracts, maybe, or indeed people who you engage on a self-employed basis. And failure to do those checks will be a breach of your sponsorship duties. And this is a bit of a concern because it goes beyond anything that we've been asked to do in the past, and indeed goes beyond the current statutory provisions for conducting right to work checks. So last year, the Border Security, Asylum and Immigration Act came into force and introduced a new definition of employer for the purposes of conducting right to work checks. But those provisions aren't yet in force. The provisions to expand the scope of who is an employer are on the statute books, but currently out for consultation as to precisely how they're going to be implemented. We have a draft code of practice which is published as supplementary guidance, which for employers when conducting right to work checks, and that includes this new definition of employer. But that's and that has a sort of proposed publication date of the 1st of October. So that's sort of our first indication as to when these new rules might come into force. And what they're looking to do is expand the scope of the of people who need to have their right to work checked. So as I've said, so this definition includes businesses hiring casual or temporary staff under workers' contracts, companies engaging individual subcontractors. I think that's perhaps a bit that's most in need of some clarification. And then also it's designed to try and capture gig economy workers, so online matching services that connect clients or customers with service providers for payment. So this yet isn't in force for non-sponsoring employers, but we now have this new, and I'll just flick back a slide with this new provision within the sponsor guidance that's talking about requiring you to do right to work checks on anyone who you directly engage, whether they're sponsored or not. I think what they're probably getting at is enforcing this definition that's contained within the 2025 Act, but not yet in force. What we think, as far as individual subcontractors are concerned, although don't have any clear steer on this in the form of any guidance or insider information from the Home Office, but we think that they're sort of driving at the sort of workers who you might sort of bring within an IR35 type scenario. So those who you're contracting with to perform services for you, who might, in some circumstances be considered as an employee, but on that particular instance, you're engaging them as a self-employed contractor. It's not going to include people who are engaged by a third-party services provider. So if they're employed by, let's say, for example, an outsourced catering function or outsourced security function, if they're employed by somebody else, then that employer, that outsourced service provider, will be responsible for doing their right to work checks. So you're not sort of looking to double up on checks that someone else has already done. It's designed, we think, to try and capture those situations where nobody's checking or nobody would, under the current or previous rules, have been checking their status. So sort of closing that loophole whereby you might say, oh, well, I don't need to check the right to work of this person because we've engaged them as a contractor, even though what they're doing looks very similar to the work of many other people within the organization. I think that's another key part to it as well, is what they're doing something which is carried out in the normal course of your business. So if we think about a school, for example, if it's a peripatetic music teacher, for example, self-employed, you probably need to do a right to work check on them because it's somebody who is providing services that help you in your operations as a school. Do you need to do a right to work check on the guy who comes out to service your boiler? No, we don't think so. Although, if you want to take an absolutely 100% compliant approach, maybe you should. It's not clear, but we have that sort of directly engage wording. So maybe if it's through a sort of another company or something, perhaps not. But yeah, we're in the dark a little bit with this one. Um, We'll come to questions in a moment. Just a couple of things to flag before we do. For those of you not aware, we have an e-learning bundle, HR and employment law for line managers, includes lots of modules on sort of various points of employment law that are relevant, but also there is a module on right to work checks which, as you can imagine, will need to be updated fairly soon, but is being kept up to date. So if you need more on that, more information on that, here is a poll, and do let us know if that's of any interest. And a member of our team will be in touch with you um, with further information. And while if we leave that up on the screen, while we're doing that, let's turn to some of your questions. So, first question, I think this was prompted by the summary I gave at the beginning of the sorts of things that people aren't reporting. So, somebody's asked, a teacher at one of our schools has been on long-term sickness. What details do I need to report via the SMS? Well, the principal thing will be that there has been if they've moved on to statutory sick pay or some other sort of reduced pay as a result of that, you would need to report that. So any reduction in pay, and I should clarify, um, uh, for the most part, you shouldn't be reducing the pay of your sponsored workers, but there are some scenarios set out within the sponsor guidance which confirm when you can reduce somebody's pay for genuine reasons. So if they're on maternity leave, if they're on long-term sickness, that sort of thing. But you do still need to report the reduction in pay. And apart from anything else, one of the reasons for doing that is it stops them looking at your payroll data that they get from HMRC, seeing that there's been a reduction and wondering whether it's for legitimate reasons or because you just didn't fancy paying them anymore. Another question: do I still need proof of date of entry to the UK if the individual was already in the UK, i.e., they were sponsored by another UK employer? Nish, do you want to pick that one up? I'm just going to grab some water.
Yeah, absolutely. So if they're being sponsored under you and they're still within the UK, then you won't necessarily need their date of entry in the UK. You would just need confirmation that they do have the visa in place to be able to be sponsored under you. So that's the main criteria under it. So if they are have a share code, then they're providing you that share code to confirm their right to work.
Great, thank you. Question here. I don't know if you know the answer to this, Nishil, from having gone through that case in some detail. What happened to the staff at Southcroft? Were they affected by the loss of sponsorship license? Were they deported?
I don't know whether they were deported, but they would have received curtailment letters for their visas to be curtailed to 60 days to either find another sponsor or leave the UK. So they would have definitely been affected by the revocation of the license.
Absolutely. Um, Here's another question. We have a cost of living increase and raises on our incremental pay scale each year. Do we have to update the system each time we make an increase? God, initially you're on a roll.
Um, I mean, as best practice, I would say that it is prudent to do it, even though it's not a mandatory requirement according to the guidance. But I think in terms of with regards to pay scales to making sure that they've got the most up-to-date data, I do think it's best practice to update the sponsor management system where where you can of any updates within salary. Yeah.
I suppose it depends on proportionality as well. Is
Yeah.
it, if you have a lot of sponsored workers, you might take the view that it's not worth doing that because it's not a fundamental, not an absolute requirement. I suppose the thing to look out for is whether with those increases there's been any changes to duties, any changes to
Yeah.
job titles, because they certainly would need to be reported. And if you're reporting a change in job title, for example, you might just at the same time say, and they've had a increase as a result. But otherwise, no, it's only pay reductions that must be reported. Um, but as Nishil says, yeah, if you have a small number of sponsored workers, you might consider it a best practice point. All right, next. For entry clearance evidence, do we need to take our own copy of any stamp showing entry, or can we accept a photo scan of the stamp from the individual? What's your view on that one, Nish?
I mean, they would have to do the right to work check in person, so you would need to see them at some point. So before they start employment with their passport and the copy of their entry clearance visa, and to check that you've seen it and that it is the person that's presented that to you. So you're not able to accept it from a right to work perspective. You do need to see the individual.
Yes, for the right to work check
Yeah,
bit. I suppose one of the issues now is no hardly anybody's passport will get stamped
yeah,
anymore. So proof of entry will more commonly take the form of a boarding card or a airline e-ticket, which would probably be emailed to the individual anyway. So yeah, you just need to satisfy yourselves really as to the date of entry. Uh, all right. What about right to work checks for voluntary workers, such as non-executive directors, council members, not paid but working for us? Um, yeah, bit of a gap maybe. I think the um, if you're a sponsor, the guidance now says for individuals who you directly engage, I mean, you will have engaged them as a voluntary worker. If they have a contract, that is. I mean, there's a distinction to be made between volunteers and voluntary workers. If they're a voluntary worker, they probably have some sort of contract, and certainly a non-executive director or a council member would be under some sort of obligation as well. And given that you are engaging them in that capacity, even though you're not paying them, I think under the sponsor guidance, you would now be required to do checks on them. Do we need to ask for CEFR record, Common European, so English language evidence, if someone has an ILR or ILR check is sufficient? Okay, yeah. So okay, I think what this is the point I made about the English language requirements increasing for
me too.
ILR purposes. And I mean, ultimately, this is something for the individual, so it's not something that you need to be checking. But if you are given, if they are asking you about, what the requirements are, um, yeah, you might want to sort of point them in direction of further information on that. But yeah, really, you're not being required to do that themselves. It's for them to ensure that they meet the requirements and for the Home Office to assess whether they've met the required standard or not. Um, how does the Home Office generally audit now, given the hybrid work setup of many offices? Do they still just turn up? Any insights on that, Nish?
It's really a mix. I mean, they can still turn up at your offices if that's your registered address on your sponsor license. But what's probably more common now is those virtual visits and asking you for documents to provide through email, and it's sometimes even not even stated by a compliance audit. So as I said, it could be just when you're requesting a certificate of sponsorship and they're looking at your undefined certificate of sponsorship request, that is when they're going to ask you for all your payroll data. They're going to ask you for evidence of your organization's chart and um, the individuals that you're sponsoring. So it could happen at any moment. So I think that's the main thing. And as Tom was saying, the Home Office is very joined up with HMRC at the moment. So if they do find that someone is requesting something or someone's changed something with their sponsor license, then they will ask the HMRC for their payroll data. So I think it could happen at any time.
Thanks, Nishal. Actually, So quite a few more questions. I'll come on to those in a moment. Just before we do, thank you for responding to the poll on the right to work checks training. We have another poll, and if you would like somebody from our team to get in touch because you would like more information about the support we provide clients with immigration, or if you have any sort of general questions and you'd like to speak to a member of the team, um, poll on the screen now. So please let us know, and Nishil or I or one of our colleagues will be in touch should you wish. Um, all right. There's a very specific question about the new entrant rate that someone's posted in the Q&A that I'm not going to answer live because I think it risks getting into specific advice and potentially even saying the wrong thing while put under pressure. So if you do have that particular question and you're really struggling with the answer, just drop either Nishil or I an email, and we'll try and get back to you on that. I've just changed the slide over, so you've got our contact details. Okay, someone else has posted. Um, we have a UKVI. Okay, I think they've missed out the word audit. So we have a UKVI audit shortly, and they've asked for a list of those on payroll. They've asked for 4 columns. Please, can you let us know what 4 columns they need? Thank you. Oh, I think I'd need to see the email from UKVI. I don't know whether they are after gross net. This isn't a sort of standard request. If it's not clear, maybe the best thing to do is to go back to UKVI and ask them if they've just maybe they've missed out some wording from their email to you. I don't know what they mean by that. Um, when are we expecting to hear about changes to eligibility for ILR extension to 10 years, for example? Um, well, the earned settlement consultation closed in February. Apparently, there were 200,000 plus responses. I read a rather worrying response that a minister in the House of Lords gave, saying that when somebody asked them how they're expecting to get through all of the responses, the answer was effectively, well, that's what AI is for, which does rather worry me. But nevertheless, it can't have escaped your attention that this has become a highly political topic within the Labour Party and beyond, and so there are lots of competing factions. We've already had one of the changes, which was proposed in the earned settlement consultation, which was the increase in the English language requirement from level B1 to B2. So some of it is already enforced, but the sort of the big ticket stuff, the extension to 10 years, we just don't know. We're expecting to hear something in the autumn. That's the sort of the noises at the moment. But quite what that's going to look like, we really don't know. Um, okay. There's another very long question that someone's posted, uh, and I haven't read it. I'm not going to read it to you live. Have you had a chance to look at it, Nishal, in the Q&A? Sorry, I'm not
Um,
putting you on the spot. I'm just going to suggest that that person maybe emails us with this question because, yeah, I don't think it's in anybody's. Well, actually, we're past 11 o'clock anyway. Okay, let's just do one more. Um, okay. For maternity pay, do we only report when the pay actually reduces, as they will receive full pay for the first few months? That's a nice, easy one. Yes, yes. It's only when they receive. Yeah, it's only when the pay starts scaling down. And you could just do one report and sort of say they will be on 90% for the next 4 weeks, and then after that they will reduce to. And I think, as a best practice point, probably also a good idea to report when they return to work and are back up to full pay. All right, we're after 11 o'clock. I'm very grateful to you for bearing with us and for joining us this morning. Very grateful to Nishal for
thank
helping
you.
me through all of that. Yes, please do get in touch if you have anything that you'd like our assistance with. Thanks very much.
Thank you.